Welcome to 1960s, Tamale, where a single receipt exhibit B sparked a legal war. An illiterate farmer paid £3 and 10 shillings for a service. But the slick scribe Bello issued a receipt for only 10 shillings. The trial judge called this stealing, but the Supreme Court disagreed. Bello names his price, £3 and 10 shillings. Without hesitation, and in front of a witness. The farmer counts out the notes and hands them over. This is an out-and-out payment. The farmer doesn't just give Bello the money to hold, he intends for the property ownership. In that money to pass to Bello immediately as payment for a job. This implies that when you pay for a service up front, the law assumes you intend for that money to belong to the service provider right there and then. Bello scribbles a receipt exhibit B, but he is playing a dangerous game, fearing the illiterate's protection ordinance, which limits what he can charge. He writes 10 shillings. Instead of the £3 and 10 shillings he actually took, Bello issued a fraudulent receipt to cover his tracks and avoid legal penalties for overcharging an illiterate client. The farmer takes his papers to the circuit court, but the dream turns into a nightmare. The judge looks at the poorly prepared documents and dismisses the case. The farmer's action failed because the documents Bello prepared were legally insufficient. Cheap or fraudulent work doesn't just cost you money, it can cost you your legal rights in court. Heartbroken, the farmer shows his papers to a literate friend. The friend gasps, "The receipt says you only paid 10 shillings? The farmer's blood boils. He knows he paid £3 more than that. The issue now is whether or not the extra £3 stolen via a trick was a civil cheat. And to law students, the issue in this case is whether or not the dishonest appropriation of money under a contract constitutes larceny by a trick. The farmer, having realized that his action failed due to the document being insufficiently prepared by Bello, and upon realizing that he had been cheated out of the £3 when a literate friend read the receipt to him, demands a refund, but Bello ignores him. It is only when the Superintendent of Police confronts him with a witness that Bello's defiance breaks. He panics and offers to return the £3 on the spot. And the superintendent rightly notes that returning the money doesn't erase the act. Bello is charged with stealing. Judge Jabana is torn. He sees the farmer was cheated, but struggles with the definition of stealing. He eventually decides that because Bello lied about the fee, the farmer's consent was nullified by a trick. The trial judge found Bello guilty of larceny by a trick, arguing the farmer wouldn't have paid if he knew the true charge. This is teaching us to beware of moral convictions that stretch the definition of a crime. Step in to correct the path. They explain that larceny by a trick only happens if the owner gives up possession, but intends to keep ownership, like a deposit, because the farmer intended for Bello to own the money as a fee for a contract. There was no taking against the will of the owner. Therefore, it could not be stealing. The difference between possession and property is the thin line that kept Bello out of prison. Bello's conviction was therefore quashed. The Supreme Court rules that Bello is a mere cheat, not a thief, since the money was paid under a valid though fraudulent contract. It became Bello's property until that contract was revoked. This established the principle that fraud in a contract makes the deal voidable, not void. Until the farmer revoked the deal, the money legally belongs to the fraudulent obtainer. To a layman, man can be dishonest and escape criminal theft charges if the victim willingly handed over ownership of the property. Bello walks free, leaving the shadow of a 4-month prison sentence behind him. The Supreme Court ruled that the trial judge made a fatal error by treating that which affords good ground for a civil claim as constituting a criminal offense. The court's reasoning was simple but powerful, because the farmer made an out-and-out payment for professional services. He intended for the property ownership in the money to pass to Bello immediately. Even if Bello had a fraudulent representation in his mind, the law states that if the owner intends to part with both possession and ownership, it is not larceny, but a mere cheat. Since the money legally became the property of the fraudulent obtainer under a contract that hadn't been revoked, the crime of stealing was never committed. The conviction is quashed, and Bello stands acquitted and discharged. According to the Supreme Court's ruling in Commissioner of Police v. Bello, the boundary between trickery that constitutes stealing larceny by a trick and trickery that is a mere cheat is defined by one critical factor: the intention of the owner to pass ownership property of the item. The core principle established is that the difference between these two offenses depends entirely on the intent of the owner at the moment of the transfer. In the case of larceny by a trick stealing, this occurs when a person is induced by a trick to part with possession only, but does not intend to pass the property ownership in that thing. In this scenario, because ownership never moved, the law views the act as a taking against the owner's will. In the case of false pretenses, a mere cheat. This occurs when the owner is induced by fraud to hand over both possession and the property. As Justice Crobb noted, quoting R.V. Rossett, if the owner intends the property to pass, there is no taking, but rather a handing over. Bello's actions were undeniably dishonest, but the Supreme Court highlights a vital truth. Immorality does not equate to statutory stealing. While the trial judge focused on the trick Bello used to overcharge the illiterate farmer, the Supreme Court looked at the intent of the owner.